Hey everyone, I just did a video on Kadrey v. Meta and I said I'd let you know when the DMCA judgment came back. I didn't expect it to be that soon, but here it is. Actually, I would have done this video yesterday, but the power was out, so it's gotta be today. Sorry about that. But this is granting Meta's motion for partial summary judgment in Kadrey v. Meta. It's a 3-pager, so it won't take us that long to go through, and we've basically already covered the facts of the case. This is about that really dumb argument I was talking about where the plaintiffs are claiming that these companies knew they were doing something wrong because they removed the CMI data before training, and that meant they were hiding their copyright infringement. It's dumb. That's why it only took him 3 pages to smack this down. He writes, "The plaintiff's DMCA claim fails because, as held in the previous order, Meta's copying must be deemed fair use as a matter of law based on the evidence presented at summary judgment. That provision prohibits the intentional removal of copyright management information by one who knows or has reason to know that the removal will induce, enable, facilitate, or conceal an infringement of any right under this title. But anything that is fair use is not an infringement of copyright. You can't conceal an infringement if there's no infringement." And I don't normally do the footnotes, but this one here I thought was an interesting point. He says, "But even if Meta did distribute the plaintiff's books, and that distribution is not fair use, the plaintiff's DMCA claim would fail. The only theory underlying the DMCA claim that survived Meta's motion to dismiss was that Meta knew or should have known that removing CMI from the plaintiff's books would conceal infringement by making Llama less likely to regurgitate CMI and thus indicate that it was trained on copyrighted material. Even assuming that, but for Meta's CMI removal, Llama would generate CMI and so reveal that it was trained on copyrighted material, there is no evidence in the record that this would in any way reveal that the copyrighted material on which it was trained was also redistributed to other computer systems via a torrenting network, nor did the plaintiffs make any allegation to this effect." And the real point that I would want to make is that it wouldn't, he says it would regurgitate CMI. It wouldn't regurgitate CMI. It would hallucinate CMI. It would make up fake CMI bits that it puts throughout things. Just like when we had those lawyers using ChatGPT or whatever to do their legal briefs and it made up those fake case references. Yeah, it would just be fake CMI. But it maybe sounds a little bit like he's already ruling out the other part of this, which is the seeding of the BitTorrent files. But I'm not too sure about that, and we'll talk about that at the end. Anyway, back up at the top of the page, it does not make sense that Congress would have wanted to exempt secondary users who make a fair use from infringement liability, only to open them back up to DMCA liability. Actually, it does kind of make sense because that's the corruption Congress was trying to do with the DMCA. If you remember my coverage of this forever, including way back in the early days of this YouTube channel, and even for like upwards of 10 years before then, basically since it was passed, I was pointing this out. A lot of these things that people are saying are DMCA abuses are exactly what the DMCA was designed to do, so that they can call things infringement when they wouldn't otherwise be infringement. That was the whole point of it, really. "It is inconceivable that criminal liability would attach to an act that was done in furtherance of a non-infringing fair use." It's kind of like the example I've used before where you have the chain of actions. You start with getting something without permission, then you do something, and you have the output. If any of those steps along the way is transformative, the end result is non-infringing. And since the end result is non-infringing, the initial downloading of the books or however you got it was not infringing either. That's fair use. It's true that the statute doesn't say that CMI removal has to actually result in infringement to give rise to a DMCA claim, but in the fair use context, the issue isn't just whether the infringement has been consummated, it's that the defendant's conduct, even if completed, is not infringement. So it's not just that you didn't go through with it, and therefore it wasn't infringement. It's that even if you had gone through with it, it still wouldn't be infringement. Alright, last page already. Section 1202B extends liability to one with limited involvement in a wrongful act But that doesn't mean it was intended to extend liability to one who has limited involvement in an act that is not wrongful in all, and in fact encouraged by the law. Third and finally, because one could intend to abet an infringement without an infringement actually occurring. But this is in tension with Ninth Circuit precedent holding that an infringement cannot have been willful where the infringer reasonably believed that they were making a fair use. If a reasonable belief in fair use is enough to vitiate intent, it would seem that an actual fair use should also be, at least where the secondary user also subjectively believed they were making fair use. In other words, if it applies to where you believe that it's fair use, it's got to apply when it actually is fair use. In other words, in the Ninth Circuit, one can't intend to abet an infringement where they intend to abet something they think is, and that actually is, fair use. It is so ordered. So, that pretty much destroys this whole CMI thing, and we've seen it being added on in other cases because they're all just imitating each other because they don't have any original ideas of their own. So one of them just comes up with a dumb idea because they're dumb and they have nothing. Then the others just mimic it. So yeah, AI training is transformative. That's fair use. That's done. The DMCA thing is done. What's left? The only thing I can think of is the issue of seeding. Because they downloaded these books from BitTorrent, the idea is when they seeded them back, they were infringing. But, he said back here in the footnote, even if Meta did distribute the books, and that distribution is not fair use, the plaintiff's DMCA claim would fail. So I don't know if we're still going to have claims about seeding or not, but that's the only thing I can think of that's left in this case. And keep in mind, the Judge Chhabria said in an earlier ruling, fact and expert discovery are closed and will not be reopened. So whatever the plaintiffs do in the future, it's got to be on the fact record as it stands, and it's not good for plaintiffs. I guess they could appeal. I don't know if you can do an interlocutory appeal on discovery or not to get it reopened. Obviously these summary judgments are subject to appeal, but I don't know. It might just be seeding that we're going on to. But just to review on that very quickly, BitTorrent you seed not only after you've downloaded the file, but as you're downloading, as you download these blocks one by one, you're also giving those blocks to other people who haven't had them already. So even though you don't have the whole file, you can still give them the pieces that you have. That's what makes BitTorrent such an efficient protocol, but that also means that if the thing you're downloading is copyrighted and you've downloaded it without permission, then even before you have a full copy of the file, you're already redistributing it. But you can go into BitTorrent settings and turn all of this off. You can have it stop when it's downloaded so it won't seed after it's downloading. You can also hit some settings that will cause it not to give out any of those blocks while it's still being downloaded. And Meta did both of those things, and they put in firewall rules, if you remember from my earlier coverage. We covered their expert explaining this. The firewall rules allowed inbound traffic only for downloads, not uploads, and that blocked seeding. And so that should have meant that there was no seeding going on. And even if there was the odd block that slipped through and got seeded, there's only a few plaintiffs in this huge corpus of books. So you would have to show that not only were those blocks that were seeded from your books, you would have to show that they were enough to be more than just a trivial de minimis is the legal term. If it's just one block, and a block I think is 16 kilobytes. And if that's not enough of your book to do anything with, then that's de minimis, which means that there was no meaningful distribution. So that's an uphill battle the plaintiffs have. They have to prove that there was actual distribution, as in actual uploading of copyrighted material, which is not supported by the current facts. And remember, fact and expert discovery are closed and will not be reopened, quote the judge. They've got to figure out how to overcome Meta's evidence about the configuration, and that includes client logs, firewall rules, and sworn testimony, and show that that amount wasn't de minimis. That sounds like a big uphill battle, but once again, it means that this is no longer an AI case. It's a copyright infringement case. So I've still got the RSS feed from the docket. I'll be getting updates as they come in, and I'll let you know what's going on. Again, I'm the only one on YouTube who is. I wish I wasn't, because I got some other things to make videos about, but hey, okay, someone's got to fill this gap. I'm here. I'm filling the gap. And if you appreciate it, then leave comments for the comment god, shares for the share throne, like, subscribe, the bell, everything to get this thing up in the algorithm. Sharing does more than anything else. Share this video everywhere, wherever you think people might be interested in it, because that gives me a little boost in the algorithm and gets it shown to other people as well. And of course, there's donate.bogosity.tv, where you can support me with one-time donations or with regular support to get these videos early and ad-free, AMAs, live streams, and other benefits. So please go and check that out. Thank you so very much for watching. Until next time, stay strong and be free.